Ladies and gentlemen, welcome to today's webinar. Today's seminar topic is Foreign versus Domestic Asset Protection Trusts, Protection and Taxation. Our presenters today are attorneys Gary Forster and Brian Page. If you'd like a copy of today's presentation, you'll find it in the handouts section of the webinar interface. And similarly, if you have a question, you can type it into the question section of the webinar interface. Okay, let me turn it over to our presenters. Go ahead, Gary and Brian.
Thank you, and thanks for attending today. Today is a very broad seminar. We're going to go through some asset protection strategies, and then we're going to lead into how trusts integrate into those strategies, and then distinguish between foreign and domestic asset protection trusts. They're very different. When we use them tends to be quite different, and the taxation is completely distinct as well. Let's get into what we're going to do today. I'm going to turn off our picture so we can see the slides, and we'll come back at the end. So let's take a look at I can do it with the mouse. I think, yeah, I'm good. I'll do it and then I'll hand it over. Today is the agenda. Here's the agenda. So we're gonna look at asset protection and how trusts are used in asset protection. We're going to spend quite a bit of time on that, and then we're going to go into the U.S. federal taxation of trusts. We're going to divide that up between domestic and foreign trusts, and then if you're not asleep yet, we're going to go into compliance, which is generally which forms you have to file, what you have to do, what you have to tell the IRS, and related topics associated with disclosure. And then we'll conclude. We've gone through a number of seminars where we talk about tax, we talk about trust, but what we realize is we want to give you some background, especially we have a lot of CPAs in the audience. They like some substantive background before we get into the tax. And basically asset protection is preparation for litigation. If you can prepare long before you have problems, asset protection can be very effective. There's generally 4 branches of asset protection, one of which are trusts. We work with titling. We think, well, how should the asset be held? If not in trust, is it held by husband and wife? Is it held individually? Is it held in an LLC? Titling, the actual ownership of the asset is very significant. A lot of asset protection really has to do with the individual or entity being sued not owning, not having title to the asset that's exposed. They're exempt assets. We call them exemptions. Basically, individuals can buy assets that are simply exempt from collection, like certain insurance, and we have the famous homestead in Florida. And that's a factor in asset protection. I'm going to skip over trust and I'll come right back. We have entities, which we now focus on the limited liability company, which the general rule on limited liability companies is that a limited liability company can acquire an asset, and that if a member, an owner, is sued on an unrelated matter, like not what the LLC is doing, but in a car accident or some bad investment or some issue that the owner has run into, that the assets of the LLC are not exposed, but the member owner can be liened. In other words, if the owner is subject to a judgment, a lien called a charging order can be placed on the member, and then any distributions coming out of that LLC to the member would technically go to the lien holder, the judgment holder. Distributions, of course, generally are discretionary, so that there is no clear path to collection by the judgment holder, but there is a lien on those distributions if they're ever made. And then we have trusts. Trusts are not a filed entity. There are some jurisdictions, some foreign jurisdictions where you can register a foreign trust, but trusts don't have articles of organization, this type of thing where you would file it with the state or with a country in general. They're an arrangement whereby a grantor, otherwise known as a settlor, funds this idea of a trust with a trustee. So the trustee would have legal title to the asset, but not in general the beneficiary of the asset. So you would divide legal ownership, which is the trustee who does not have access to personally benefiting from the assets, from beneficial ownership, which is for as an example, a parent funds a trust with a trustee for a child. So the trustee would not have access, but the trust would benefit only the child. And what that did is it divided title in the sense that one person, could be a company, one person holds legal title and another person benefits from the assets. So if the person who holds legal title is sued, that person really doesn't benefit from the assets, so there's no exposure to the assets. And then if it's a discretionary trust, if the beneficiary, the person who benefits from the assets, is sued and suffers a judgment, the beneficiary doesn't hold legal title, can't control monies coming out of the trust. Therefore, there is no money to be reached by the judgment holder, even if the judgment holder has the right to collect against that beneficiary. The trust assets are not generally available. That's why trusts are so protective. There's, when you see trusts and there's mandatory distributions, you have to keep in mind those mandatory distributions, you now have exposed them to creditors of beneficiary. That's one example where so you can get a flavor for how trusts work. The reason we wanted to have a slide on general asset protection before we went into just purely trust law is so you can understand, if a client comes in, the steps we take to understand how best to protect the client. We look at titling. In other words, if a doctor comes in, or a lawyer, or an architect, or someone who could have individual liability, well, if that individual acquires assets by the entireties with their spouse in Florida before there's a problem, those assets are not available to creditors of the professional. So if someone sues a doctor on a malpractice claim, or some type of professional liability claim, or a lawyer or an architect or whatever, assets held with the spouse by the entireties, you have to make sure that the titling is correct, are not available to the creditor. The drawback to this kind of easy titling is that if in fact someone falls in a home, or husband is driving wife's car, or wife's driving husband's car, you actually could have joint liability. If there's joint liability, tenancy by the entirety does not protect the asset. So it's not infallible. It does have holes in it in terms of exposure. So what do we do in those cases? Well, then we implement the LLC a lot of times. So we basically say, okay, tenancy by the entirety is not going to work all the time, or you're in a state or a jurisdiction that doesn't allow tenancy by the entirety. Several Midwestern states don't allow tenancy by the entirety with personal property that is not real estate, or not with real estate, or whatever their rule is in that particular state. We say, well, we'd like to get tenancy by the entirety, but it's exposed to joint claims, or in our jurisdiction it's not allowed. So we drop the assets into an LLC in a jurisdiction that allows for tenancy by the entirety. So basically, we insulate the asset. We basically eliminate someone suing a member's ability to get the asset, but remember, the LLC is subject to lien. So we try to avoid the lien by having the LLC held husband and wife by the entireties. So if you're in a jurisdiction that allows entireties, it's no issue. If you're not, we create an argument that you form your LLC in a jurisdiction that allows by entireties, and then you take by the entireties under that jurisdiction's laws. Is there an argument in your jurisdiction that that's improper? Maybe, but at least you have the argument that you now have the entireties. You've eliminated the lien issue. What if you're not married? If you're not married and you want to insulate the asset in the LLC, you may run into the single member LLC problem. In Florida, for instance, it's a very limited protection of a single member LLC. If the single member becomes subject to suit, the assets are generally exposed to foreclosure. So we look at trusts. Does a single individual have the ability to insulate that LLC from lawsuits, from individual lawsuits? And we look at not the traditional trust, which is I form a trust for somebody else, father or mother forms a trust for child, because since the 1500s, basically you have to form a trust for somebody else for that trust to be insulated from creditors of the grantor. So a few offshore jurisdictions in the 80s said, no, you can form a trust for yourself. So that goes against the historical precedent, but those statutes insulate trust assets from claims against the settlor. The states got a little jealous because a lot of money was moving offshore into these foreign trusts. And so now 16 states, started with Delaware and Alaska. Nevada has a nice statute. South Dakota has a great statute where you can form your own trust. So if I have these exposed assets and I want to put them into an LLC, but I'm a solo member, I can't create tenancy by the entireties to protect that LLC equity. I may want to form one of these self-settled trusts. And this seminar, after that unbelievably long-winded background explanation, is about the trust, the self-settled trust. We added that just because I think it adds some, it kind of sets the table for what we're going to do here. Let me go to the next slide. I had mentioned that the first asset protection trusts really were foreign asset protection trusts. Typically, what had happened was the idea of the trust is an English concept, and the foreign jurisdictions that started offering these foreign trusts, mostly in the 80s, late 80s, were English held or English commonwealths, and then who had at some point sought typically independence. So their structure, their legal structure is based on the English format. If you get away from the English format and you go to European, what some people like to call Napoleon
civil law.
Civil law, exactly. There's no trust. There's not really a trust. There's the fidei, which is an idea that's kind of similar to the trust, but the idea of placing assets and dividing title, so to speak, it's more of a contractual idea.
Right, and it's also based on the idea, and at least in civil law, of what's called a usufruct. That's the term, but it's distinct from the Anglo-American version of a trust, which developed in England during the Middle Ages when people would go off to the Middle East. Yeah, the Crusades. That's how it really started.
So if I don't come back, I want my brother to hold these assets in trust for my children and wife or something like that. And so it created like that. Then it started to get utilized for tax purposes, and the idea of the legal title and the beneficial title came into play against government claims, and it developed over 500 years. So the foreign jurisdiction that had developed this started to offer this foreign trust, but they said, this idea though, where you can't form your own trust, and if you form it, the assets aren't protected. We're going to eliminate that. We're going to go ahead and protect the assets anyway. Under our law, let's say it's, we like Nevis, and there's a number of former British colonies that offer this. It's protected. We've got a few cases here that are interesting. Generally, what happens is if someone is playing around or has abusive activity with respect to foreign trusts, like they have a creditor and they're running away from a creditor, and it's a fraudulent transfer, that's another seminar. But it typically exposes trust assets or any assets in any kind of protective plan. Courts are very, very likely to try to somehow find a way to reach those assets. Now, with foreign assets, if the assets are actually offshore, the court has no jurisdiction over the trustee or the assets. So what happens is, we don't have all the cases here, but there are a number of mostly bankruptcy cases that basically what the court says, you know what, we can't get those assets. So although these other assets you have domestically are maybe otherwise unavailable, we're going to make them available, or we're going to disregard the trust because under the laws of Connecticut where you live, you can't do this. Just unbelievable, the rulings. But the idea is that it was an abusive practice and it went offshore, and the court's basically going to try to disrupt that. So we only, do asset protection planning when the skies are blue. There's no issue. We'll do an overview, for instance, if someone has a problem in terms of what we think their exposure is, but really asset protection at that point is very limited. This first case, this Wells Fargo v. Barber, was a completely abusive situation where a woman, actually from Orlando, had a Miami connection as well. She had borrowed, I think it was $64 million in the housing boom. Everything crashed, and she was given some actually poor advice. She had money in a homestead which she actually could have retained. She moved the homestead a number of times. She started to use an offshore LLC. And basically what had happened was, just as an example, the court said, no, you've got an offshore LLC, but we're going to call it a Florida LLC and take all the assets. In this case, the assets, believe it or not, were actually, she left them in Florida. So they were taking it. So we under no circumstances, as strong as a foreign trust would be, would recommend any kind of scrambling after there's a problem. It basically, it's all done when under blue skies. An opposite ruling was very interesting also in Florida. It was an appellate ruling, this Sargent ruling, where a developer got into trouble. And I think it was Alcala was the owner and sued the developer for basically, retaining monies and misusing monies. And it looked like a judgment, Alcala got the judgment against Sargent. But I think what had happened was, part of the assets were held in corporations, right? And so the idea was, once I have a judgment in Florida, I can go ahead and enforce it in Florida and take assets that are in Florida. But the assets, the only valuable assets that were available were stock certificates. Stock, by the way, unlike an LLC, is completely unprotected from creditors. But the stock certificates had been moved offshore. And this was a very debtor-friendly ruling where the court said, look, you've got your judgment, but we have no jurisdiction over those stock certificates. So you cannot collect here in the States. You have to go abroad. So of course, what that means is they're just going to keep moving the stock certificates around until the creditor gives up. The Rush University case, is the third case, was one of those cases where an individual had promised certain assets to the medical center, but the assets had been moved offshore to a foreign trust, whereby the court said, look, these assets were tied up, they were lien. You can't just shirk on your commitment to the charity. We're going to ignore the trust. So you have to be careful with these trusts. They will get ignored, and extra careful if you're going to hold any assets in the States. This is one of the strongest asset protection vehicles of foreign trust. But if you're going to play around and if you're going to hold assets in the States, you have to be very careful to do it, to plan when the skies are blue. There's no problems. There's a number of options you have with trusts. This seminar is, a lot of the focus going to be, do we go foreign, or do we go with one of these domestic asset protection trusts in one of the 16 states that offers it? So there's some general considerations. When we do a foreign trust, Brian and I, we basically There's a tremendous due diligence process from the trustee. There's questionnaires that go on and on. A lot of times there's even an Interpol. They'll do their own Interpol search. There's a lot of compliance, tax compliance issues that we're going to go through a little later. It's very involved.
A lot of know your customer forms, a lot of background information. The source of the funds or the assets are important as well.
Especially if assets are placed offshore,
Right,
which they
right.
really should be.
And then you also have the question of not only where the assets are, but where the trustee is located, because of
Oh, sure.
the jurisdiction of the court. You might have a foreign trust, but if the trustee is in Florida, let's say, then that Florida court would have jurisdiction over the trustee because they're here.
Yeah, that would just be a mistake, but that does happen. We do see that from time to time. So the domestic is somewhat easier to set up. It's less expensive as well. It's quite
the compliance is much less because it's domestic and it's disregarded for taxes.
Usually it's disregarded for taxes.
It's grant trust.
So we wrote a couple things down on the slide. So the full faith and credit. So basically what happens is the full faith and credit clause of the U.S. Constitution basically says that if you get a judgment in one state, the other states have to respect it. So you always have this issue where if you get a judgment in Florida that doesn't offer asset protection trusts, I can record it in any state and it's effective. Now, can I collect against the asset protection trust in a foreign jurisdiction? We've actually defended against those cases when someone comes in and says, I've got this asset protection trust in Nevada. I've got a Florida judgment. They're going to record it in Nevada, and we have successfully defended those cases. But it remains an issue. It remains an issue. I mean, you can still record in these states. Let's say there's a Nevada asset protection trust. The client has property in Ohio, right? The assets are in the asset protection trust. The ruling, the judgment's in Florida. Well, the client can take the Florida judgment to Ohio. Ohio doesn't have. Well, they recently, I think, invoked an asset protection trust, but it's not their asset protection. Let's say it's a Nevada asset protection trust. What happens? We don't know. And let me tell you, nobody knows. We don't know what that judge is going to do, and we have instances here in our litigation team where it's absolutely clear what the outcome of the case is going to be, and it doesn't happen. So we don't know in those cases because there's too many jurisdictions involved, and that's a domestic issue. If the money goes offshore, right, into a protected foreign trust, and the trustee's offshore, it's very, very difficult to reach. That's one of the differences in terms of protection between domestic and offshore. But a lot of people like domestic. It's more convenient. It does offer some protection. We'll talk about, how to bolster the protection, but it's not like offshore. Even though it's not as convenient, it's more expensive.
Yeah, and I think it's important to note that most U.S. states, for public policy reasons, don't allow a self-settled trust. For historical reasons, they've maintained the common law and that.
Yeah, only 16 states.
In Florida, it's actually in our trust code. It says in there in a statute.
It does not protect.
It does not.
If you contribute to your own asset, it does not protect you.
It becomes a rev trust, basically.
It becomes ignored with respect to collection claims against the grantor. This is from my asset protection book. This is just something that gives you an idea. And if you, of course, at the end of the slide, if you want this presentation, just send us an email or call. This gives you an idea of what some of the different foreign jurisdictions offer. Some have changed slightly. This is a couple years old, but it gives you an idea when you choose which jurisdiction, who you want to go with. Another factor, as we can attest, is some of the jurisdictions are much more sophisticated in terms of setting it up. They have a lot of trust companies there. It's just easier. Which is, if you don't want to wait and you want to deal with sophisticated groups as much, it's a factor also. This is the domestic side. When we go with a asset protection trust, we have an LLC. We've got a single individual. He or she just wants some kind of protection from that charging order, that lien. We go with one of these states. Here's a little background. You can set it up for yourself. But it's only in the 16 states, not in Florida. We've got a lot of Florida listeners, and in some regard, untested. We will go through a few cases on the domestic asset protection side before we get into the tax work. I think they're very insightful, actually, the cases. The first case is called Uber, and it establishes the precedent. It's a bankruptcy case. These bankruptcy cases come up all the time. The rules are really quite different than in the civil court. The judges are much more aggressive and have much more power. So you get some bizarre outcomes, but you also get a flavor for the arguments that the creditors make. A very nice insight into where people are going to go to break these trusts. This was a developer who set up an Alaska asset protection trust. He was a Washington resident, and one of the co-trustees was a Washington resident. That's the next case. I thought we actually have a slide. It's not here from another presentation. It goes into some depth into Uber, but I'll give you the depth. So basically, the assets though remain in Washington State. There was a co-trustee in Washington State, and I believe there was a protector, which is someone who governs distributions, who has a veto right on distributions of the trust. So what happens with these trusts is all the connections to the trust and control, or almost all, kind of slip back into the jurisdiction where the individual with the assets is sued, the assets are, and everybody else is. And it really gives the court the ability, especially in bankruptcy, which we really rarely recommend, to say, you know what, this really isn't an Alaska trust. I know it sounds crazy, but this is what goes on, especially in bankruptcy. This isn't really, there's a trust document. I mean, it's all there. It's signed, sealed, delivered. There's a trustee in Alaska, at least one of the trustees. But the court's like, you know, this really isn't real. So we're going to ignore it. And the court ignores it. And so what happens is all of these assets are viewed as not in anything. And the court in bankruptcy just takes them, gives them to the trustee, gives them to the creditors. That's very infrequent in the civil court. Usually you have to have a legal claim. This was a public policy quote unquote public policy claim. Public policy used to be like, if I kill myself, I can't collect on my life insurance, or like there's some kind of criminal act. But what's happening is used now to reach into these plans in bankruptcy. It's rarely used in civil court. So you have to be careful with bankruptcy, but it gives you an idea that, a court will sit through an entire litigation, an entire trial. The plaintiff will win. The plaintiff will register the judgment. All of these resources and time have been spent, and at the end of the day, the defendant says, no, everything's protected. That does not make the court happy. So you have to be very careful and meticulous when you form these plans. With respect to these asset protection trusts, you should form a connection. If we do an asset protection trust, for instance, in Nevada or South Dakota, we want to make absolutely sure that the accounts, if it's a national brokerage, they link their Nevada charter. Your account is through Nevada. There's a Nevada trustee. We try to create some link to Nevada with the grantor if we can.
LLC as well.
We use a Nevada LLC to hold the asset, and we try to have a protector in Nevada. That's because of this issue with connectivity. In many cases, they're enforceable anyway outside of bankruptcy, but we don't know. We don't know what's going to happen. So it's very important to create that connectivity. The next one's the funniest case ever. Okay, so it's funny to us, but not to this Mortensen. So this guy, Mortensen, was a mountain man in Alaska. He creates an Alaska asset protection trust. He's in Alaska, so there's no connectivity issue. He's in Alaska, the trustee's in Alaska, he sets the thing up. I have not seen the trust, but apparently it was not beautiful. It was kind of semi done on his own, crafted, pieced together.
Internet forum, probably.
I don't know. I don't know what it was, but apparently that's the story. So he's just kind of set though. He got the thing in place. It's got the trustee on it, and he ends up getting a divorce. Okay. Now, divorce is also usually a very bad way to test an asset protection plan because there's so many equitable remedies in divorce. Oftentimes, the foreign asset protection trust, long before divorce, is the best way to deal with divorce. Of course, the best way is a prenuptial, postnuptial agreement. But divorce is very, very tricky. But what he does is he sets up the trust. The assets have been there for the statute of limitations. What that means is you transfer to a trust on a clear day, nothing's going on, and after 2 years, creditors are going to have a hard time reaching those assets because you did not transfer with the intention of avoiding a creditor, and the time period has passed. That time period has passed in Mortenson's case, so he was fine. I'm not sure anyone knows the whole story, but he then later on, I don't call it 5 years, starts to get into a divorce proceeding. I guess he got concerned or didn't retain counsel, and then files bankruptcy. Bankruptcy on the asset protection side extends the statute of limitation to 10 years. He falls back into the statute of limitation, loses all the assets. It's absolutely nuts. You feel bad for Mortensen, but I mean, just the slightest bit of competent counsel might have resolved that whole problem. Anyway, it's something to keep in mind. It goes back to connectivity. You had the connectivity, but really of bankruptcy, the general rule with bankruptcy is if you don't have assets, right, you go bankrupt, it's a discharge of liabilities. What are you going to lose? The problem comes when you have assets. You've got to think about it, because if you have exposed assets, you've got to give them up in bankruptcy in exchange for the discharge of indebtedness. It's more complicated than that, but people with significant assets very rarely go bankrupt because they don't want to give up the assets. Here's where we talk about the keys to this connectiveness. Where are the people involved? The settlor, the trustee, the beneficiaries. Where are the assets? Have I retained too much control of the assets, or does the trustee truly control the assets? Avoid being Mortensen in bankruptcy, and then we just have these issues where you want to, like, don't be egregious. Is just a general idea. For instance, a great example would be when you create the self-settled trust, put your family in there as backup beneficiaries. Do it as part of an estate plan. Save some estate tax as part of your asset protection trusts. And with that being said, we're going to go into the tax side, and I'm going to go to Brian because I'm kind of exhausted, but I'm going to chime in.
Yeah, no, it's a lot there.
And Brian's going to go through some basics, and then how the foreign and domestic asset protection trusts are taxed and what we need to look at.
Yeah, sure. Just a lot of these vehicles, as relates to the domestic and the foreign trust, you have two levels of taxation you need to be aware of, and you need to be concerned about. One of is for U.S. transfer taxes. If you make a completed gift, you're going to have to, the client will have to utilize or harvest their unified credit, which in 2020 it's 11.58 million per individual, which is extremely high, which is great, but we know in 2026 it will reduce down to 5 million plus inflation, and then depending on what happens in November, it could go away even sooner. So that's something to keep in mind. Generally, when we prepare these documents for our clients, especially if it's offshore, we typically, it's not really an asset protection. I'm saying it's not really an estate tax, plan. It's more for asset protection. So we would make it an incomplete gift, so we wouldn't have to worry about this. There are certain things you retain to have it be incomplete, but just need to be aware that, if you do want to make a completed gift and it's irrevocable and it's gone, that you have to know these amounts, and if you exceed the amounts, you'll have to pay a tax.
And then Brian also is going to go into this incomplete gift issue. Completing a gift means it's outside of your estate and in one of these protective trusts. But there's a huge red flag and trap for the unwary associated with these completed gifts for foreign trusts. It's just something to keep in mind. We're going to hit on that in a few minutes.
Right. And then you also have the annual gifting. If you proceed to take it for an irrevocable trust, you're able to give $15,000 per individual, or $30,000 if you're a couple per individual. If you use a crummy letter, just something to be aware of, and it's there for trust. The gift tax is just imposed. I know this is a lot of basic, but just to give you a flavor, if you make an inter vivos or during life transfer property, and you have released dominion and control, you're going to have the gift tax apply. It's a completed gift, and then so you would then allocate your credit. It's part of the transfer tax. They're unified. One is during life and one is at death, but at the end, the exemption amounts are the same. And you just need to plan how you're going to utilize those for your client.
And now's a really, in terms of the age we're in right now, this moment, it's almost like you have to almost assume that gifts now may not be able to be made soon.
Yeah,
and you're going to have a free gift period for $23 million for husband and wife, which may go away. And will become a taxable gift.
It's very likely. Between just the politics of right now in the country, but also our government doesn't have any money. And this isn't a real big. That's the reality. It's not really a big revenue raiser, but it looks good for the politicians to say, hey, we're gonna, reduce this down. So just keep that in mind. And this is this type of planning needs to be in an overall estate plan as well, just so we really leverage these techniques. The other difference is it's just that the gift tax is an exclusive tax and the estate tax is inclusive. What that means is that if I'm the donor and I make a gift to Gary, he gets the full amount of the gift, and I, as a donor, pay the tax out the side of the gift.
I'm waiting for that gift.
Yeah, I know he's waiting for it. And as opposed to the estate tax, which is when they look at the entire size of the estate and the tax comes out of the estate itself, the gross value. So that's the difference. It actually enables the individuals to you're able to give more in life than you can at death if you utilize your credit the right way. Mm-hmm. And so that's just something to keep in mind. So if you have the ability to do it, the inter vivos during life transfers are best for this type of planning. Kind of talked about this, but what is a gift? Just a completed gift is just when the person who makes the transfer has given up all dominion and control. They've released all the strings of control over the gift, and the person who receives it, the donee, owns the gift. An incomplete gift, and this is important when it comes to trust, the grantor or the settlor can make a transfer into a trust, but if they retain some strings to what the trust does, they are able to make it incomplete for taxes until their death. And that's important because if you have an offshore trust, we'll talk about here soon, you don't want necessarily for it to be a completed gift because of the income tax consequences of that.
It's tricky. Yeah.
And then you can also have a part gift, part sale, which is if you sell an asset for less than the fair market value, the IRS might impart that on you to say, okay, this part was a gift, this part was a sale. Just keep that in mind. We also have to worry about if you have a gift, or if you have a trust that is multi-generational beyond the kids. If you go to the grandkids or lower, the Congress thought it was unfair that you could potentially avoid the estate tax at each level, so they imposed the GST tax. It's just there. You need to be aware of it. And it's, they want to make sure that at every level that if you exceed the credit amount, you would pay basically another state tax. So the credit amount for the GS&T and the gift and estate are the same. So if you have a trust and you allocate your entire amount of the credit to the trust, that trust from then on would be free of any type of transfer tax from now on. If you don't, you have an inclusion ratio of 1 or 0. If it is, then the entire amount can be. We tried to divide those out so you don't have a trust that is partially GS&T exempt and other one not. So something to keep in mind. But these are the type of planning that if you take steps on your own, this can be a pitfall and have to pay a tax.
Oh, it happens all the time. We have people coming home, grandkids.
Right. And we talked about what these are. There are 3 types of actions that would cause the GST tax to occur. One is a distribution. That's if a trust makes a distribution to a skip person, which is just a grandkid or an individual that's 37.5 years younger than the person who made the trust. Termination is when a trust terminates and they distribute out the full amount, or an estate is over and they distribute out the remainder. And then lastly, a direct skip is just a direct gift. That's it. Pretty straightforward. Okay, those are the
general estate.
General estate. Now we're going to talk about the nitty-gritty here for domestic trust. What does it actually mean when you create a domestic trust? How is it taxed for income taxes, and why? Because a lot of times when we prepare these, as I said before, it's not an estate tax planning mechanism. It's more for asset protection, but the income tax side will affect the grantor and or the beneficiaries and or the trust, depending on how it's structured.
That's a good point. That's a good point, because a lot of people we find we have to fix a lot of these trusts, and they actually, when you unwind it, they actually went into these trusts, even though it wasn't a concern, the tax, they stepped all over the tax code and created and triggered all kinds of tax problems. That's a good point. Even though that's not the purpose,
right,
you still have to avoid the problems. Yeah.
And so it's important to understand what happens and how these are taxed. But you can find these rules in subchapter J of the code. It's divided into 5 parts. What's important for us is really, chances are if it's a domestic asset protection trust, it's going to be a complex trust because we want to sprinkle distributions and want it to be discretionary.
Yeah, they're all going to be.
Yeah, I mean, you'll never see a simple trust because it would eliminate, if you have mandatory income distributions, it's not protective.
So basically.
Yeah. So, and the other thing is, if you do have one of these, you could have the throwback rules. If you don't distribute all the income in a given year, later on, if you distribute part of the principal that includes that income, there might be a potential tax you need to be aware of, accumulation tax. Just that the main thing is that a trust by itself normally is a distinct tax-paying entity unless it's grantor. And a grantor trust is disregarded, and the individual who made the trust or potentially made a transfer to the trust would be imputed the income from the trust. And that's important because of the marginal tax rates for a irrevocable trust that's not a grantor. You're the marginal rate at basically a little bit over $13,000.
We're talking about income tax.
Income tax,
not estate tax. We're talking about income tax, a totally different format, different net. Everything changes. So on the income tax side, a lot of times you want to create grantor trusts because it's just a grantor. It's disregarded, like a single member LLC, sometimes disregarded. And the actual payment of the tax associated with those assets, even though in trust, maybe even gone for estate tax, state and gift tax purposes, but still with the grantor for income tax purposes, is not an additional gift to pay those taxes.
Right. So it's an additional way to pass wealth.
That's right.
That's why, I mean, it's interesting. They created these rules to stop certain things, and then it ended up being another mechanism.
We had to call it defective for 2 decades or whatever.
That's right. It's kind of interesting how this all works out.
Defective.
And just that, the trusts are like an individual, so their tax rates are in 1E and they're tiered, but basically you're at the marginal rate at $13,000. I think it's 13,100.
Yeah, you're at 40%.
700 or whatever it is. And depending on the terms of the trust, you can potentially push out the income on K1 to the beneficiaries. So sometimes you're able to push out the income to beneficiaries in a lower bracket.
Yeah.
Which is, you know, a technique
That's
that can be utilized. The main difference between the way that they're taxed, if you have a simple trust, you have to meet the 3 requirements. You have to basically distribute all the accounting income in a year. You can't have any charitable distributions or set-asides, and you can't distribute corpus.
Yeah, that's uncommon that we would create simple trusts, but it's good to understand the differences in the code and how they're taxed.
And in complex trusts, is if it fails any of the 3 requirements, it's a complex trust. Those are the basic rules. Regardless of the classification, it gets an annual deduction, and it's kind of small because this was written back in 1954. But they're $300 for a simple trust and $100 for a complex trust. So you can see huge amounts of money. I guess back then it was, but not so much anymore. It's not indexed or anything. Just these are basic rules, just so you understand. Simple trust, you distribute all the income out, which means that all the income is pushed out to the bennies, so they would record it on their individual returns, and the trust gets a deduction equal to the amount of income it distributes out. And then it maintains its character. So if it's ordinary, capital gain, or tax-free. Those are very basic rules. Complex is a little different. It can accumulate the income, so depending on what happens, if it distributes out, it can push it out depending on the tiers, and then it can also hold on to it because you want to be able to sprinkle it and you want it to be discretionary, which is important for the asset protection trust because you don't want to have a mandatory income distribution. It would eliminate the purpose for the beneficiaries if they're forced to receive income from the trust.
Then their creditors can take it.
Right. And the trust would get a deduction if it distributes it out. And be careful with the accumulation throwback rules. We see this a lot. It's a very complicated 5-year running average way to calculate this, but just be aware that this does come up if you accumulate income for a period of time, and then in a tax year you distribute out corpus and it exceeds the income in that year, you're going to be subject to this trust.
You're going to throw up.
Yeah, the tax. Yeah, it's awesome. Yeah, throw up, exactly. Now, why is that important? Well, when we create a domestic trust, the domestic rules will apply. If we create a foreign trust, there's a new regime. And the income tax consequences at times aren't what we expect. But as a basic rule, all U.S. persons are subject to income tax. And the same thing with the estate tax. So depending on where it's located and where the individual is, the basic rules apply.
Being a U.S. person for income tax is not the same as being a U.S. person for estate tax. So there is a lot of planning that we do, especially for foreign individuals, where they could actually be an income tax resident and not an estate tax resident, or vice versa. For citizens, it's much more difficult to plan.
And the main test is for income tax. It's either the green card test if you're non-citizen, or substantial presence. And then for the estate tax, it's based on domicile, which is your physical presence and intent to remain. So they can be different. For non-U.S. residents, non-citizens, it's only U.S. source income that is taxed. And there are some exceptions to that. The most important one are stock sales, intangibles, which is a huge one.
Yeah, very few people understand that. If you're not a resident or citizen here, you can trade U.S. stocks and bonds not related to real estate at no capital gains tax.
Right. You'll have treaties involved at times, depending on their country of origin. There are some passive income rules, the 30% withholding rules, depending on the FDAPI income.
That's U.S. source income.
Right, from U.S. source. Then if you have effectively connected income, it's graduated rates.
So one of the things that we tried to keep this as straightforward as possible, obviously it's complicated, is you get into, U.S. people creating foreign trusts. Is it a foreign trust or is it a domestic trust? We're going to get into that. But we at the firm, also have another layer now. If you have a foreign person coming in or a foreign person investing here, that creates a whole different set of facts and applicable tax code. So it's very significant exactly who is involved, where they are, and who they want to benefit, because the tax rules can be completely different between even brother and sister who have slightly different factual scenarios.
Gary, we have a question. Stock sales, does this apply to private equity or private company shares?
Yeah, and intangibles are not taxed. So unless they're real estate based. Also on the estate side, U.S. based intangibles are not subject to the gift tax.
But if you own them at death, they will be subject to the estate tax.
So it's a pitfall. So you have to give away your U.S. intangibles, or you end up having to pay estate tax on them unless you plan otherwise.
And that's with a $60,000 exemption amount.
There's no exemption.
Yeah, it's almost nothing.
Almost nothing.
As relates to foreign trust, there's no tax to a foreign trust unless, if there's no effectively connected income or U.S. real estate gains. That's really where.
Yeah, it's like a foreign individual. It's like a foreign individual.
And then U.S. beneficiaries are taxed when income is distributed to them.
So another question here. So then if we're talking about, foreign versus domestic trust in our conversation here, so a Florida trust with foreign beneficiaries and a Florida trustee is still considered a domestic trust. Is that correct?
A Florida trustee?
A Florida trust and a Florida
trust with foreign beneficiaries and a Florida trustee.
Yeah.
It's a domestic trust based on those facts.
Yeah, it's a domestic trust. Well, I think we have a slide on
there's a two-pronged test, the court test and the control test.
That's right.
And basically, the court test is, does a U.S. court have ability to bind the trust? And the answer is yes, because it's a Florida trust. And then where's the trustee?
That's right.
And in Florida, which is the
trustee, right. Yes.
If it fails either or both, it's foreign. So international taxation of trust, it depends. The income tax depends on the facts of who made the trust, who created the trust, where the beneficiaries are, and where the assets are. And also how was it created and when it was done, because of the rules we'll touch on. But if a U.S. resident makes a foreign trust with U.S. beneficiaries, which is the most common when it comes to asset protection.
To U.S. residents. Yeah.
There is a exception to the income tax rule to where it's treated as a grantor trust during the lifetime of the grantor, or as long as there are U.S. beneficiaries. As long as those two things are there, there's no income tax change as relates to the assets inside the trust. It's just the income you normally would recognize would be reportable by the grantor of the trust. So that is the main thing. So when we create these, the idea is we make it an incomplete gift for transfer taxes, and it's a grantor trust for income taxes. So from the perspective of taxation, it's as if the grantor still owns the assets there, so he or she would pay the income. So there's not really a huge change. There are some compliance requirements regarding forms, but the overall taxation is pretty straightforward. When that changes, that's different. If a person dies and they still have a foreign trust with U.S. bennies, or if the foreign trust no longer has U.S. bennies anymore, then there's an income tax.
It's a deemed sale.
Recognition of it, deemed sale under 684.
That's coming. Yeah. We're coming toward the end of the hour, so we'll try to wrap it.
Yeah, there's just know that there are special rules for NRAs as relates to their assets, and then we talked about the $60,000 exemption amount. Just to be aware, you don't want to own things. You want to utilize potentially a foreign corporation to own, especially U.S. real estate would be the main one.
Absolutely.
Just keep that in mind. Foreign trust, right here, there are two tests. It's the U.S. court test, the control test, and the court test. So if you have a Florida trust with a Florida trustee, the beneficiaries are irrelevant as relates to how it's taxed. It's a domestic trust because all the stuff is in the United States.
But more interestingly, if you have a foreign trust with a U.S. trustee, right?
Right. Then
you could slip into domestic even. I guess what happens practically
domesticated
is but people form a foreign trust, right? Or they form. Actually, what just happened was people form a U.S. trust. They think they've got a U.S. trust, and they appoint. This was Norway. They appoint their uncle in Norway to be a trustee.
Oh no.
And so what happens is, I'm just trying to give you an example of these dingbatted shifts kind of thing. We've now shifted. Now it's a foreign trust, even though it was formed in Florida, and all the compliance and tax changes.
Right. You have a deemed transfer of assets from the U.S. grantor on the date it became a foreign trust to a foreign trust. So regardless of the transfer taxes, you have an income tax deemed sale.
Even though it was formed in Florida.
Right. That's right. That's right. It's a pitfall. It can be very dangerous. It's important who.
That's a good example too. That comes up. Yeah.
And it's important as I think we covered this a minute ago, but we can prevent this deemed sale for these types of domestic, for the foreign trust, we can prevent the 684 deemed sale by having a U.S. grantor and U.S. beneficiaries. It postpones the deemed sale until the earlier of the U.S. grantor dies or there are no more U.S. beneficiaries.
Well, also, I mean, what happens is there's planning that goes on at the onset, whereas if the U.S. grantor makes a completed gift, you're going to have a deemed sale upon his death, his or her death. And if we don't make a completed gift, it becomes part of the estate, and he gets a step up in basis,
So there's
and then
no
you can
deemed
avoid.
sale.
There's a deemed sale,
Yeah,
but it's no gain.
There's no gain
There's
because
no
you
gain.
have a step up.
Let me get another question in here. Would a foreign foundation with non-U.S. beneficiaries holding U.S. assets, how would that be treated?
Foreign foundation
with non-U.S. beneficiaries holding U.S. assets, how would that be treated?
Who formed it? Who formed it?
Yeah, okay. So, Brian, if you want to tell me who formed it, let's go to the next one. Okay, he says a non-resident.
Okay, so a non-citizen formed. So it depends. See, the foundation is going to slip into a different. Let's say it slips into the trust definition. If it is considered a trust, it's an offshore trust formed by a foreign person for foreign individuals, right? So you have a fully foreign situation. If you're an individual and you're foreign, or you're a trust or you're foreign, you're kind of looked at the same way. And the U.S. says, okay, we don't really mind what you're doing, except with respect to U.S. source assets and income generated in the U.S. or sales generated in the U.S. will move back out to those assets, and we'll create a tax liability. And Brian, in a couple slides here, if we can slip it into the hour, is going to show you what you'll have to comply with when you do that.
Yeah, and let me slip in one last question here because we're at the top of the hour now, so we'll let you go another couple minutes. So based on the previous statement regarding foreign trusts, what if the Florida trust with a foreign beneficiaries has a protector who is foreign? Is that considered?
Protectors, at least as relates to the control test, it's the trustee, it's the distribution trustee. Where is that individual or company located? That's how now the trust protector, depending on its terms, if they potentially could control distributions, normally a trust protector is just a veto right. That's my understanding the majority of the time, or they can remove the trustee.
Usually, but you can call people Bob. But if
Right.
that protector has trustee powers,
it could potentially
you can pull it off. You can
could.
pull it off, sure.
Yeah. So it depends on the terms of what the powers are of the trust protector.
Okay, let's bring it home now, guys.
Yeah. So Brian's going to work through compliance and close it up.
Yeah, this is the last little part here. Just these are some forms. If you have a offshore trust with a U.S. Benny and a U.S. grantor, these are the forms you need to be aware of. The main one is Form 3520. It's filed annually by the U.S. resident treated as the owner of a foreign trust. It's due with their 1040. So, and then that includes
all of
extensions.
These match. All of these
Right.
go to grantor and beneficiary.
Right. It's all informational for the IRS. This return will have a statement as well from the form I'm about to talk about next, which is the 3520A, which is from the foreign trustee, which is here, and it's also required to be filed annually, and it's due by March 15th of each year. It will have the U.S. owner's statement as well as the foreign grantor trust beneficiaries statement, which must be filed for the beneficiaries as well. Then lastly, the U.S. Benny has to also file at the 3520 each year. Just keep that in mind, even if nothing's taxable. You also have the FATCA forms, 8938, and the FBAR forms, depending on the values and what we're talking about, what's at stake.
Thanks so much for attending. So